Good evening and welcome to the regular meeting of the San Francisco Ethics Commission. We'll begin by taking the roll. Commissioner Studley.
Here. Thank you all. I'm sorry for being late.
Commissioner Liu.
Here.
Commissioner Hayon.
Here.
Commissioner Rennie.
Here.
All members of the commission being present. Let's begin with the agenda. The first item on the agenda is public comment on matters appearing or not appearing on the agenda of the Ethics Commission.
Good afternoon, Commissioners, and of course, stop the corporate rape of the public library. Don't give money to the Friends of the Library. Don't accept money from the Friends of the Library. You may remember that Jewel Gomez violated someone's constitutional rights in violation of the Sunshine Ordinance on June 4th, 2009. You made a finding that she was guilty of official misconduct and made a reference to the mayor that the mayor should consider terminating her appointment on July 12, 2011. You followed up with a direct request to the mayor that he respond to you with some sort of explanation on September 24th, 2012. I followed that up with an immediate disclosure request to the mayor on December 3rd, requesting any documents reflecting any internal consideration or any any documents indicating a response to your follow-up letter. What I received was a email that a constituent of Supervisor Kim named Andrew Adams, which he sent to Jane Kim on September 28th. That was the only thing that I received. What's significant is that Mr. Adams' contact information was redacted in that response. Nothing else, no indication at all that they had considered any possible response to you or any consideration of a possible response to you. You have to realize that redacting that contact information is the City Hall equivalent of flipping somebody the bird. It's been established by the Sunshine Ordinance Task Force and the courts in this state that a person can't invoke somebody else's right to privacy by redacting their contact information, and once it's waived, it can't be re-invoked again. So they have no grounds to redact that contact information, and they know it. This would be the equivalent is if the finding of official misconduct against Ross Karimi was responded with, well, we're friends with Ross Karimi, and we don't have to give you an answer. In fact, nobody said that. But in this instance, it's a badge of honor. They don't have to give you a reason. They haven't given you a reason. It's not official misconduct if it's only the Sunshine Ordinance. And that's a very heavy message. Thank you very much.
Commissioners, Ray Hartz, Director, San Francisco Open Government. As the previous speaker mentioned, Jewel Gomez has been reelected to her position twice since you found her unanimously to have violated her responsibilities under the Sunshine Ordinance. And yes, the mayor has refused to even deal with it. Now, it's very interesting that over this last year, he didn't mind spending $200,000 of city money to try to get Sheriff Mayor Karimi out of office, and used your recommendation to put it to the Board of Supervisors to try to do that. And yet with one of his own appointees, you send him a recommendation, he ignores it. You send him a letter asking him why he ignored it, he ignores that. Well, boys and girls, can anyone spell hypocritical? You know, very frankly, one of the reasons I have been so adamant about the Library Commission is the fact that they come before the public and they lie. They present numbers relating to the finances of the Friends of the San Francisco Public Library, and now through public records request, I have found they have absolutely nothing to back those numbers up. We're talking $10 million that they have claimed the Friends gave to benefit the public library, and they can't back up the numbers. and yet they come before the public and say, oh, yes, they're doing a wonderful job. Now, at the minimum, that's misrepresentation. If I am on a board or commission and I go before and I present finances as a part of a public record, and I say, oh, yes, these are good numbers, and it turns out that I don't know what I'm talking about, that's dereliction of duty as far as I'm concerned. That's malfeasance in office. And that's what the Library Commission does. Each and every month, they come before the public and they say that friends gave us this money, and you say, well, show us something to prove that, and they're just silent. We went before the Government Oversight, General Obligation Bond Oversight Committee, and we said to them at one of the documents, we said, you know, the number here is not a valid number. And they asked them questions of the Chief Financial Officer of the library, and she admitted, yes, we don't have anything to back those up. At that point, it was only $6 million. Now it's up to 10. In fact, it went from $1.6 million in January of last year to over $10 million by the end of the year. And none of that was contemporaneous documents. It's all them going back now and trying to justify all the lies they've been telling to the public in the prior years. And I've also got a sunshine order against the city librarian for withholding public records, primarily because he didn't want it exposed that he didn't have any idea whether those numbers that were presented were valid.
Good afternoon, Commissioners. I'm Patrick Manette Shaw, here on my own time as a private citizen. First, I'm going to ask Mr. Rennie to recuse himself when you get to my item again, given my article about Mrs. Rennie's foundation in last month's West Side Observer. Second, I'd like to know when this commission is publicly going to inform members of the public what the delay is with the mayor removing Ms. Jewel Gomez. You've let that matter drag on for a year, 4 months after your determination, and you're letting the mayor just ignore this commission entirely. Drawing your attention to Alan Grossman's analysis of the October 22nd hearing on my two matters. He outlined 16 questionable steps about how the October 22nd hearing progressed. First point, getting around the Ethics Commission's representations to the San Francisco City Attorney, San Francisco District Attorney, me as the complainant and other respondents, and the San Jose City Attorney's Office, that this commission cannot adjudicate cases involving its own executive director. No problem. Next issue. Getting around your blatant conflicts of interests, playing both judge in the appointing authority for your respondent executive director. No problem. Next issue. Having the commission chair, that would be Mr. Herrick, review the San Jose City Attorney's report and formed an opinion on the merits of my case before he allowed me as the complainant to provide any response or to hear the case in an open public meeting. And then Mr. Herrick commented to the Deputy Executive Director of Ethics, who reports to the Ethics Director, that the respondent in the two cases, is there any reason why we can't just release the San Jose's excellent analysis about why Shaw's complaint fails? No problem. Next issue. We just charged right through that October 22nd hearing with all sorts of irregularities about how you conducted that hearing. Number 11, allowing Chair Herr, who should have recused himself because of his opinion was on the record before the hearing began, to vote on the substantive questions involved, thus improperly providing the 3 required votes, since conducted that hearing with the bare minimum of commissioners present. Thank you.
Hi. My name is Paula Dadish, and I have a serious issue with the San Francisco Arts Commission. I have a street artist permit, and I've had a lot of problems. They've violated the Sunshine Ordinance repeatedly over so many years, and it's really affected my life. I've been speaking to your ethics office about problems posting the minutes of the executive committee. They haven't posted in years. And I just hope that you really do a thorough investigation on them, because there's a lot of things wrong with the way they run the meetings. Thanks.
The next item on the agenda is our changes to our enforcement regulations. Mr. St. Croix, would you like to introduce this matter?
Yeah, these are largely housekeeping matters in following up on the changes that the Commission has already made, and are pretty straightforward and I think self-explanatory.
There are 3 decision points. The first is, shall the Commission approve the addition of Section 3D as set forth on page 3 of the enforcement regulations? The second is to approve the deletion of other references to the Sunshine Ordinance and the enforcement regulations. And the third is to change the definition of business day to comply with the Sunshine regulations that we propagated previously. These seem to me to be pretty straightforward administrative changes. Is there any discussion on these? Okay. Anything from the city attorney? Public comment on this item.
Good afternoon. My name is Dr. Derek Kerr. My comment is not specific to the Sunshine Ordinance modifications, but does refer to Section 6A of your enforcement guidelines. My recollection is that the civil grand jury, when they did their report on the Sleeping Watchdog Ethics Commission, they pointed out that having 2 commissioners call for an issue to be calendared is too high a threshold, because the executive director can find that there's no probable cause, can advocate for dismissal of a complaint, but that can be challenged by 2 or more commissioners. So at the discussion of the Ethics Commission, my recollection is that the commission agreed that 1 commissioner could question the executive director's dismissal and have the item calendared. But here in your enforcement guidelines, it still says, thereafter, any 2 or more members of the commission can cause an item to be calendared. So I'm just raising the issue of whether it's 2 commissioners or whether it can be just 1 commissioner. Thank you.
Commissioners, Ray Hartz, Director, San Francisco Open Government. You may wonder sometimes why I come here and seem so angry. Well, it's because I have 14 orders of determination from the Sunshine Ordinance Task Force finding various commissions, boards, city employees in violation of the ordinance. And basically what you get when you get one of those orders of determination is a body who will then look at it and simply say, well, we don't give a damn what the Sunshine Ordinance Task Force says, we're not going to do it. We don't care what the law says, we're not going to do it. And then when it's referred over here, up until this effort on your part to actually enforce it, none of them were enforced except for Jewel Gomez, which we talked about earlier, which basically was ignored by the mayor. So are we going to just go through this evolution again? I mean, basically what we're talking about here is denial of due process. The law of the San Francisco gives the citizens of this city the right, when they feel documents have been withheld which shouldn't have been, or have been denied the opportunity to make public comment, the avenue of going to the Sunshine Ordinance Task Force and asking for their assistance. But what good does it do you? You go there, you get the orders of determination, and yet other city agencies, including this body, just ignore those determinations. Know your rights under the Sunshine Ordinance is printed on every agenda of every commission and board in this city and every meeting. And yet when people who actually do know their rights under the Sunshine Ordinance come before these bodies and simply ask to have their rights respected, their constitutional rights, for heaven's sakes, they get met with open hostility. I went to a meeting, a public meeting, earlier this month, and every time I got up to speak, one of the commissioners simply crossed his arms across his chest and rolled his chair away from the dais and back into the corner. And when I got done speaking, he came back up to the table. And you say, well, yeah, maybe Mr. Hart, you deserve that. No member of the public deserves that. Because what it is sending a clear message to members of the public: we're going to say the words, we want you to be here and we want you to participate, but we don't mean it. Earlier this evening, the Arts Commission had a meeting where they tried to blame an expense of the Sunshine Ordinance Task Force complaints on certain individuals, when it was them sending people who couldn't answer the Sunshine Task Force questions, who couldn't respond appropriately, and who simply ignored the law and dragged it out for as long as they could. Blame the victim.
Good evening, David Pilpel. I have no quarrel with the proposed changes to the regulations. I only had a comment on the titles, actually. The current regulations are titled Ethics Commission Regulations for Investigations and Enforcement Proceedings. I think it would help in some ways to add handling before investigations, and more to the point on the new regulations regarding Sunshine Ordinance matters. I would actually title that Ethics Commission Regulations for Handling Alleged Violations of the Sunshine Ordinance. I think it's confusing to suggest that they're regulations for violations when they're not necessarily violations. It's the procedures for handling alleged violations. So those are my only comments about titles. The substance is good and fine, and I commend it to you for your approval. Thanks.
Patrick Manetcho again. Commissioner Herrick and honorable commissioners, I respectfully request that you ignore Mr. David Pilpel. As you well know, complainants start out filing a complaint. They spend endless hours waiting for their items to be scheduled, calendared at SOTF. They go through a rigorous process of evaluating alleged complaints. But when the Sunshine Task Force finishes their determination, they do not title and forward to you an alleged order of determination. They send you an order of determination. Don't put the word alleged in your title of the new proceedings, because at the point a Sunshine case ends up in a referral for enforcement at ethics, it's no longer an allegation. Thank you.
With respect to the titles of the ordinance or our response to the ordinances and our handling of the ordinances. I think the titles are fine. I don't know if any other commissioners have thoughts. My view is that we do handle some sunshine complaints directly. We handle some that the task force will have made a determination on. But ultimately, I think the regulations are clear and the title accurately reflects more or less what we're trying to do with them. Thoughts?
I agree. I mean, I suppose we could say Ethics Commission regulations for complaints made under the Sunshine Ordinance, but I think violations is fine too. Either way, I think is fine.
Any other thoughts? Does the city attorney have any view on that?
John Givner, Deputy City Attorney. Your current titles are fine from a legal perspective. The proposed title is fine from a legal perspective. The one thing I would say is you shouldn't amend any portion of the sunshine enforcement regulations tonight because that's not on your agenda.
Mr. St. Croix, can you respond to Dr. Kerr's question about 6A?
Dr. Kerr is actually correct. The bar is now one commission member can calendar a complaint. I'm not sure why this copy went out, but it's either typographical or was an old copy. But it is one that's already been voted on and in effect.
Thank you. Any other discussion from the commissioners on this agenda item? Is there a motion to approve the changes?
You can do them en bloc if you want to.
I do. To the changes to the regulations for investigations and enforcement proceedings?
Second.
All in favor?
Aye.
Any opposed? Hearing none, the motion passes. The next item on the agenda is discussion and possible action on the report submitted by Lisa Herrick, formerly of the San Jose City Attorney's Office. As you'll recall, and it has been referenced previously, on October 22nd, 2012, we held a hearing on this matter relating to ethics complaints brought by Mr. Manette Shaw. We also reviewed and considered paper submitted by Mr. Shaw and heard argument from Mr. Shaw on the matter. During that hearing, we asked Ms. Herrick to review a number of communications to determine whether she believed they should be disclosed. She subsequently conducted the review and then identified a set of email that she believed should be produced in redacted form. So this item agenda is then to discuss whether those emails should be produced as redacted, and if so, whether that has resulted in a willful violation of the Sunshine Ordinance by the Executive Director. Any comments from the commissioners on this matter?
Do I not get a 5-minute rebuttal on this through the discretion of the chair?
Mr. Metshaw, I'll give you a little bit of extra time during public comment and let you speak first, but I would like to hear from the commissioners.
Thank you.
As I recall, this relates tangentially to the subject matter of the two complaints in which I recused myself for reasons stated. The issue being raised in this particular instance does not appear to involve the same or doesn't go to the merits of the two underlying complaints, but I would propose that I not participate in the disposition of this question.
I have no objection to that. Commissioners, objection to that? And I assume there's no vote or action we have to take with respect to Commissioner Rennie's recusal.
You should vote to permit Commissioner Rennie to recuse.
So moved.
Is there a second? All in favor? No public comment on whether Commissioner Rennie should recuse himself?
Thank you for your integrity, Mr. Rennie.
All in favor?
Aye.
Aye. Opposed? Hearing none, the motion passes. Commissioner Rennie shall be recused from discussion of this matter. Any other views from the commissioners on whether this document should be disclosed?
I would find it helpful if someone could recap the standard for redaction. What is disclosable, and by what standard one would determine what redacting is appropriate?
So,
Or unless what we are being asked to do is purely provide these documents as redacted or not at all.
So my understanding, and I'll perhaps pass it on to Mr. Givner to go over the standard. I have printed out for myself some of the relevant sections, but
You were ahead of
to recap procedurally what happened, Ms. Herrick reviewed and determined that the redacted portion was privileged. That was covered by state law and or local ordinances that protect the disclosure of this information, including C3.699-13A. So her proposal, I believe, is to produce the information as redacted.
Not having that section at my fingertips or in mind, and I don't. But it's hard for me to make a judgment on this without knowing what that privilege, knowing more about the nature of that privilege that would require that certain information be redacted. I'm going back to her memo as well. This is the longer one. Okay, thanks.
Following up on Commissioner Studley's question, is the privilege standard that we're looking at the one talking about all drafts, notes, preliminary reports, controllers, benchmarks, studies, audits, investigations, and other reports shall be confidential?
That is
Oh, that's the first part of it.
first part.
And then the second part of the standard is records of any investigation shall be considered confidential information to the extent permitted by state law?
Correct. And then there is the Evidence Code 1040 section defining official information.
Okay. And that portion we don't have in our memo right tonight?
Not from the recent
Okay.
memo, but
Okay.
here it is if you want to take a look at it.
Oh, right, okay.
Mr. Givner, have I missed anything?
No. I was just searching to see if I had Evidence Code 1040. I would note that Section F1.110B involves whistleblower complaints, and the second section you noted, C3.699-13, involves Ethics Commission investigations.
Commissioners have any objection to taking public comment right now?
No
that'd be
objection.
Mr.
fine.
Mr. Shaw, I'm going to give you a chance to go first, and I'll give you 5 minutes.
Thank you.
May I make a suggestion that it sounds like what you're offering to Mr. Shaw is something outside of public comment, that as a party to this proceeding, you're giving him 5 minutes, and that you then, after Mr. Shaw's 5 minutes, open up the floor for public comment.
Okay, we can do that.
Why, thank you, Mr. Givner. I'm turning into Mr. Chatfield my 150-word testimony that I will email you so you don't have to rekey it, introducing typos. I'm sorry, can you hand me that copy back? Oh, never mind, I found what I was looking for. So you will recall that when I was here in October, I testified that 1040 doesn't apply. I also testified quite strongly, both here and at the Sunshine Task Force, that C3.699-13, it doesn't apply either. I have been denied access to these records for 2 years. It's been a long wait. Sunshine Ordinance Section 67.24B1, Roman numeral 3, regarding access to litigation material states, quote, advice on compliance with, analysis of, an opinion concerning liability under, or any communication otherwise concerning the California Public Records Act, the Ralph M. Brown Act, the Political Reform Act, any San Francisco Government Ethics Code, or this ordinance, end quote, are, and pay attention to this, are public records, subject to disclosure. Notably, Section 6253C of SIPRA gives agencies 10 days to notify requesters whether the requested records are exempt or disclosable, and that if an agency fails to notify the requester in a timely fashion, it waives any applicable exemption. Now, 2 years after I filed this records request, you're going to tell me that the 2 years is not that much longer than 10 days? Sorry, but you don't get to claim an exemption now when you had 10 days to do it, when this case was first referred to you and you sat on my case for a whole year. Do I have your attention, Ms. Dudley? Moving along, the emails that Ms. Herrick identified are presumptively public records. And so Mr. St. Croix has to identify any particular exemption that you may now be attempting to rely on. There is nothing in the charter, as Ms. Herrick admits, that exempts those emails. They are emails. They are not part of the investigative file. Second, the non-internal emails, which Ms. Herrick wrongly claims are confidential under Section F1.110B, are not, in fact, covered by that section. Although she underlined the operative description of the confidential documents, the word, quote, communications, or any word that would describe an email is missing. Under the constitutional requirements for public access, these statutes must be read narrowly. Thus, the description of what is confidential can't be expanded to cover communications, which are a completely different animal in the investigative file that was the subject of my complaint. Those should also be disclosable unless otherwise exempt. And once an investigation is closed, I maintain that it becomes a public record and the entire file needs to be released. This commission should ask for an explanation from Mr. St. Croix about why he forgot that these emails were in the file. You should have been made aware of that at least by last October 22nd. And it took Ms. Herrick, in my humble opinion, the wrong jurisdiction to arrive at that conclusion for you. So I am encouraging you to release those emails. It's your ethical duty to do so. It is not your ethical duty to dream up some new exemption to withhold them any further.
Public comment on this matter.
Commissioners, Ray Hartz, Director, San Francisco Open Government. As I mentioned earlier, every agenda of every board and commission in this city has on its agenda Know Your Rights under the Sunshine Ordinance. And yet it is really, really a Sisyphean task to push that rock up the hill and get people to actually follow the law. For example, this body, in my 150-word summaries, which I had 4 orders of determination from the Sunshine Ordinance Task Force, all of which were ignored until at some point somebody made a decision that my 150-word summaries would actually go in the minutes as required by the law. Now, there's no explanation about that, simply changed. So now I've got one issue that's being handled by 4 different commissions in 4 different ways. Trying to get documents is one of the most frustrating things that a citizen in this city has to deal with. You want to get involved in a public issue. You want to get, in particular, financial records. And yet, city employees, in this case, or in my case, Luis Herrera, the city librarian, used his office to withhold public records from me. He just basically didn't want it apparent, he didn't want it made apparent to the public that all these claims they were making at library commission meetings had no basis. That $10 million that was claimed as a gift to the branch library improvement program was just that, nothing but claim. And so when I went and I tried to get these documents, he held off for 9 months. And now we have Mr. Manette Shaw. He comes to you and he's wanting to get documents about a complaint. You know, filing these complaints is kind of like a black box. You drop it in the top and whatever comes out, you're expected to live with. Same goes with the Office of Citizen Complaints at the police department. I had a city police inspector lie to me about the existence of a document. He repeated that lie to a deputy city attorney when I petitioned for the supervisor of records to make a ruling, told her that there was no document, and then 3 months later, oh, exemption. As Mr. Manette Shaw says, you have a certain number of days, a certain time limit to claim the exemption. If you just followed the law, we wouldn't get into these issues. But you don't, and they drag on for years.
Good afternoon again, Dr. Derek Kerr. Along with Dr. Maria Rivero, I was one of the whistleblowers who exposed misappropriations in the gift fund that is at the root of this sunshine concern that Mr. Manette Shaw has raised. What really struck us was the inordinate delays in getting our concern attended to, both by the Ethics Commission and the Whistleblower Program. We also had complaints about Department of Public Health contracts, conflicts of interest, and those complaints took over 2 years to get resolved, at which time we had been driven out of the hospital. So, having talked to almost a dozen other city whistleblowers, all of them experienced the same retaliation. There's no whistleblowers who get away in one piece. So we have lingering concerns that the Ethics Commission is complicit in burying whistleblower complaints and in enabling retaliation and destruction of whistleblowers. I think it would help everyone, particularly the whistleblowers, if you would release something. And you can honor confidentiality, but you don't have to get into this ridiculous secrecy where nothing can be revealed, because that feels like you're doing something wrong. Thank you.
Yes, good afternoon. Thank you. And I think it's very important to say a few words in support of Mr. Monette-Shaw on this issue. And the memo, the two memos, the one from your staff and the one from the outside attorney, are regrettably ambiguous. Mr. Monette-Shaw is quite right to point out that unless something is specifically exempt, it's by definition a public record, period. And it's a public record and disclosable unless it can be withheld under one of the specific sections of the state law. And if you look at the two charter sections that have been quoted, both of them are set out within the scope of the applicable state law. Now, the memo before you says that we're not exempt from disclosure, but may be disclosed. Well, a determination that they may be disclosed means that they were public records and your obligation is to disclose them. Now, I can't help but observe, because it's come up so many times, that the Ethics Commission is supposed to be the most ethical of City Hall bodies. And the fact that you've been repeatedly challenged on your own openness and willingness to disclose is, I'm afraid, of the essence of this entire question. And my compliments to Mr. Monette-Shaw for being so fastidious and so faithful in his commendable pursuit of this issue. Thank you very much.
David Pilpel again, speaking as an individual. Several points. I was not on the task force at the time when this matter was heard, and so I'm continuing to speak on the matter, having not heard it when it was before the task force. Also, I believe I raised at the October meeting this particular nuance about email communications that might have gone between the commission staff and the controller's staff that were not part of either investigatory file, which is what led to this. For that, either thank you or I apologize, or we're just working through this. I think it is pretty clear that all of these records are public records. I think the question is whether these are records subject to disclosure, and to that end, whether they're subject to disclosure in a redacted fashion, going to Commissioner Studley's question. Based on the memo that I've seen in the public file from Ms. Herrick, I agree that those records that are part of the investigation, study, audit, or other report from the Controller's Office are confidential under Charter Section F1.110, and those records of the Commission that are pertinent to an investigation are confidential under Charter Sections C 3.699-13. However, Ms. Herrick identified 3 pages of email that don't fall into either of those categories, in her opinion, and are therefore subject to disclosure. This is obviously a complicated analysis looking at state law, the charter, and the Sunshine Ordinance. In this case, I believe the Sunshine Ordinance is trumped by these 2 charter provisions that make certain records confidential, and to the extent that they're confidential under Evidence Code Section 1040 and not subject to disclosure. But again, to the extent that these 3 pages don't fall into those categories, I believe they are subject to disclosure in a redacted fashion.
That's not what the SOTF ruled. Okay. Mr. Shaw, please. You've had your opportunity to speak. Mr. Pilpel, you may continue. Mr. Shaw, please give Mr. Pilpel a chance to speak. Thank you.
So to conclude, I believe that those 3 pages should be provided. Neither memo discusses what the staff's rationale for nondisclosure at the time of the original request was. That may be something that's worth discussing, so I think it goes to the question of whether there was a willful violation or a different sort of matter. I believe that Mr. Monette Shaw is free to make a request at any time, particularly now if he believes that the matter is concluded, and to the extent that there are records that are available post a concluded investigation, there may be additional records that are now subject to disclosure. I mean, it really turns on what was available at the time a request was made. So, and just my final point, I am particularly troubled by the fact that apparently the Commission has received either all 24 pages or at least the 3 pages and is able to review and consider those which the public obviously hasn't seen, because that's the subject of the matter before us. I don't find in the Charter or in the Sunshine Ordinance a provision that allows the equivalent of in-camera review of documents in this way, and I'm still struggling to work through that issue. But I'll deal with that on my own, and I'll let my comments stand unless you have any further questions. Thank you.
Thoughts from the commissioners on this item?
Can I ask Mr. Givner to address that point about the in-camera review?
Sure. Let's say documents that are distributed to a commission for their review that are not otherwise privileged or protected by law must be made public. So the staff's memos to you on public matters, if they distribute them to you, they must be made public, and they're attached to the agenda packet. Confidential documents that are protected by a privilege can be distributed to you and are not part of the public file. And one example of that is if you are considering legislation that raises potential legal issues that could lead to a legal challenge, we sometimes will give you a confidential memo that's protected by attorney-client privilege. You may review that before the meeting. You don't make that public. In this case, the documents that were distributed to you, the city has made an initial determination through the executive director that those are confidential. The commission tonight may decide that those documents are not confidential, and then they will be disclosed. But at this point, it was proper for the San Jose city attorney to provide you those documents in confidence.
Okay, thank you.
Any other comments from the commissioners?
Well, I guess I'm just not sure. It's not clear to me that the text of the emails meet the definition of confidential information. That is what I'm struggling with a little bit here, but maybe I need to be directed in a more analytical fashion.
My view of this matter is that, as redacted, I think Ms. Herrick is correct that the information can be publicly disclosed. Now, I'm not sure how enlightening or satisfying the redacted information, the redacted version will be. It appears that the information that was redacted relates to communications between the Commission and the Controller's Office, which we previously determined were covered by this privilege as part of the investigative file. So I don't think Ms. Herrick was making any additional determinations beyond what she had initially recommended and that we had initially decided on October 22nd. I think she's simply enforcing that view and decision by redacting the portions that were otherwise privileged pursuant to our prior determination. So that's my understanding of what happened here.
Okay. And that it was privileged as part of the Ethics Commission investigation or as part of the Controller's investigation?
Well, I think we, and Mr. Givner, correct me if I'm wrong, I think we determined that both are. I think these emails may have been as part of our file, the Commission's file, but it relates to both.
Okay, thank you.
Commissioner Ham.
So my question is, in terms of the opinion that's been rendered by Ms. Herrick, are we bound by that decision, or is this simply advisory and we can decide what we think?
We are not bound by her memo. We made our decisions at the October 22nd meeting, and as part of that, we asked her to review some additional documents, and she has now come back with a recommendation stating that she at least believes that
Right. No, I read the recommendation, so I understand
should
that.
be produced. So I don't think we're bound by this memo that she provided today, or that is part of today's packet.
But her opinion certainly should help us, decide and vote on whether these three emails are public or not. Is that right?
Right. And what I hear Chair Herr saying is that this memo is consistent with the actions we took, the discussion we had at the last meeting about this, and that we'd be applying that same standard, that we think that matters, communications between the Comptroller's Office and the Ethics Commission staff cannot be revealed, but that communications within our staff, the fact of such communications and any part that is not restricted by being about a communication between ethics and Comptroller can be revealed. So that she's following on that interpretation.
And this was this is what you discussed at the October meeting?
This was discussed at the October meeting.
Yeah.
I'm not.
Do you have did I say it incorrectly?
I think you said it a little more narrowly than we decided.
Okay.
To the extent that a communication with the Controller's Office relates to an investigation, that is covered. So, and internal communications, I don't really want to make, it's probably more accurate to rely on what we decided and said at the meeting. But with respect to internal communications, what Ms. Herrick appears to be saying here is that if you redact the confidential portions, i.e. the portions that relate to the investigation, the fact of the internal communication could be disclosable. Again, I think I shared my view that we should follow Ms. Herrick's recommendation to produce the redacted document. With respect to whether this is a willful violation of the Sunshine Ordinance, I do not think it is, and the reason is as follows. This was part of the file. It's been heavily redacted as a result of containing confidential information that is protected, and I think it was right to withhold the document. Mr. Givner, what is our ability and or our requirements with respect to redacting and producing documents?
Point of order.
That would be otherwise.
Through the chair, point of order. I could have sworn that the agenda for tonight said that you were going to arrive at making one decision before you began evaluating whether it was willful. So straying into the willful part of it before reaching your first step appears ethically wrong.
Mr. Minette-Shaw, please sit down. Mr. Givner.
So, is your question?
Are we obligated to produce confidential documents in redacted form? Or if they contain confidential information, should they be withheld?
I think that Ms. Herrick's approach and suggestion is correct, that if there's a document that contains a little bit of confidential information that can be meaningfully redacted, and a chunk of information that is public, that the Commission has to produce the public portion. Just to make sure that all the commissioners are on the same page, I believe in reaching the conclusion that the documents are public, or the non-redacted portions of the document are public, you're concluding both that these documents, these redacted records, are not records of an Ethics Commission investigation or the Controller's investigation, and also that they're not covered by the official information privilege. And I think that's Ms. Herrick's recommendation to you.
Or that we find that they are not part of, in redacted form.
Right.
The official records exemption. Okay.
Could you just, I got the first part, that the redacted documents are not records of an Ethics Commission or Comptroller's Office investigation, and the second leg?
And that they are not subject to the official information privilege, which I believe Ms. Herrick spoke about in her first memo from September or October. The official information privilege is a privilege in state law that protects information gathered in confidence with an expectation of confidentiality from the informant, and involves a level of balancing by the government entity looking at the record whether the public interest favors disclosure or non-disclosure.
Interesting. Little background music for your hearing pleasure.
I've arranged with SFG TV for all of my legal advice to be scored.
Choreography comes next.
Well, Chair Herr, you've answered my question on the analysis. So I just needed to be reminded of the analysis that had been rendered at the October meeting. Thank you.
What would be the appropriate motion to effect do we need to take an action to allow the release of these documents, or is that self-activating by the city attorney's, San Jose city attorney's determination?
My understanding is that we would have to vote to release.
And what would be the appropriate motion to accomplish that?
I think the motion would be to release the document as redacted by Ms. Herrick. Before we do that, this was calendared as a single agenda item. I do take Mr. Minette Shaw's point that they're separately enumerated within item number 4. But I do think we can take them together. Is that right, Mr. Givner? Okay. Although it is sort of difficult to not take them in order. Let's make the motion on whether or not to release the 3 pages as redacted by Ms. Herrick. Is there such a motion?
So moved. I move to release the documents as redacted by Ms. Herrick.
So, second.
All in favor?
Aye.
Aye.
Opposed? Hearing none. That motion passes, and the records should be redacted, or should be produced as redacted. As a result of having agreed to produce the records as redacted, I do think we should address the issue of whether the failure to release these documents was a willful violation of the Sunshine Ordinance. I think I've given my view that in light of the effort we made to review all of these documents, the discussion we had, an argument we heard with respect to the this file and these records, that I certainly don't see willfulness here myself. I open it up to my fellow commissioners to share whatever views they may have on the matter. Then we'll take public comment and go from there.
I agree. I don't find a willful violation, given the amount of time we had to spend in analyzing the issue ourselves. That was borderline, I think.
I'd be interested in hearing public comment first.
Public comment on this item.
Commissioner Herr, I know you just want me to go away quietly at night. Okay.
Mr. Minette Shaw, if I wanted you to go away quietly, I'm pretty sure I wouldn't have given you the opportunities to speak and present papers and review and delay so that we could fully hear your argument and understand them. I hope that at a minimum you feel that I've given you an opportunity.
Can an ethics commission that speaks the English language tell me how Merriam-Webster's definition of willful has not happened? This case has dragged on for 2 years. Before it got here, it was willful foot dragging while it was winding its way through SOTF. As far as I'm concerned, you're foot dragging in agendizing my complaint almost a year after it was referred from SOTF. That your foot dragging was also willful. You could have scheduled a special meeting to move things along. It's willful that Mr. St. Croix and his staff, his deputy director, the entire ethics commission, ethics department staff, more than likely had access to that file. They knew what was in that file. Withholding it under the misguided interpretation of 1040 and C3699-13. All of that was willful. I think Ms. Herrick made the recommendation that the material should be released, knowing that it was willfully withheld, that it existed in the file all along, and that had you, as commissioners, done an in-camera review of the entire file, instead of just an in-camera review of 24 pages, 3 months after you made your decision on October 22nd, you could have looked at that file in camera before October 22nd. And you may have known then that it was willfully withheld then. And maybe you would have reached a different outcome when you considered my case. Instead, Mr. Herr prejudiced the October 22nd hearing, which, with all due respect, sir, was willful prejudice.
Dr. Derek Kerr again. Another issue that comes up with these complaints and investigations is whether the Ethics Commission or the regulatory agency does anything, does any investigation. One way to find out is to request documents. The documents are not confidential. It's the information that's confidential. For example, if you request information about a FBI investigation, they might send you documents that are completely black with nothing except black on it. But you know that there's a document, that something was done. So if we ask for something, a document or some information, you could still give the public a document and hold on to the information. That way we know that something was done on paper, but that we can't have the information. Thank you.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I think it's kind of circular reasoning or some sort of, I don't know how to describe it, to say that because it took us 2 years to get to this point, it obviously wasn't willful because it was complicated. The law says you have a certain period of time to produce documents or explain why you're withholding them. Period. It doesn't say, oh, well, you get a couple of years to sort of toss it around and decide whether you're going to hear it or not and decide when you're going to hear it and whatever. And that's why I said it's a Sisyphean task, pushing that rock up the hill when you are a citizen and you do know your rights under the Sunshine Ordinance, to get anybody to actually follow them. And I think it's really self-serving to say, well, because this was so complicated in our mind that it took us 2 years to reach this point, that you can't say it was willful. And the reason I say that is I was in customer service in the private sector for a number of years. And if a customer came and had a complaint, you could do one of two things. You could simply ignore them, or you could say, let's actually have a conversation and talk. Let's see if we can figure out what the problem is and come to a resolution that both of us can live with. And what I have experienced, not only from the Ethics Commission, from a lot of city boards and commissions, is their unwillingness to deal in good faith. In other words, instead of sitting down with you and saying, okay, what is it you want, and giving you what they're supposed to give you, giving you what they're allowed to redact but still are required to give you, and then saying, here's what we've withheld and here's the law under which we've withheld it, nobody does that. They simply say no. And if you force them to look into it, they'll drag it on and drag it on and drag it on and drag it on, I guess hoping you get hit by a bus. There's never a good faith effort to say, look, you've said these documents are disclosable. I'm sitting with you with all the documents. I'm giving you all the documents that are disclosable. I'm giving you some additional documents which are disclosable, but we've redacted some things. And I've given you a list of what we've withheld and exactly under what law we have withheld them. That's the way public records requests are supposed to be handled. Not, you figure out what it is we withheld and why we withheld it and all this other stuff, and then come here and try to present a case for 2 years to finally get something, and then we'll say, well, we weren't willfully withholding it.
David Pilpel again. I think we're working through this issue, and I appreciate your time. We've heard at least a couple of times from Mr. Monette Shaw on this matter. We have not heard from Mr. St. Croix, and as I suggested earlier, and under the regulations that were adopted 2 months ago and took effect, if this matter were coming before you now, we would have had a report and recommendation from the staff and an opportunity for the complainant and the respondent to speak. So we've heard from the complainant. We've not heard from the respondent. It would help me to understand from Mr. St. Croix what the rationale was for non-disclosure at the time, and that would have informed my public comment at this time. So I find it difficult to opine as to whether or not there was a willful violation absent hearing from the respondent and their basis for non-disclosure at the time. I think that would be proper both under the regs that were adopted 2 months ago and under the circumstances that we find ourselves now. So I would encourage you to ask him that. Thanks.
Other comments from the commissioners? Commissioner Sudley, you said you wanted to wait for public comment. Is there anything else you wanted to share?
No, I agree with you and Commissioner Liu. I don't find this to be willful. I sense that the understanding of that this was part of the investigative file and the degree to which was made and could well have been made in good faith. And that the fact that we have teased apart this particular category of communication within the ethics staff as being the one place where there might be documents that were appropriately disclosed suggests to me that that was a reasonable basis.
Would any of the commissioners like to hear from Mr. St. Croix on this?
Yes.
I think that would be helpful.
Mr. St. Croix, can you come to the podium, please?
In terms of the 3 pages of documents in question, once redacted, they're rendered meaningless, and as such, provide no usable public information. And so, just in defense of that, it's not withholding any information that is usable by the complainant or any member of the public.
In that regard, I found Dr. Kerr's comment informative. My organization files FOIA requests and records requests with the state, and I think there is a difference between a document, however frustratingly redacted, and no document at all. That said, I can understand that determination was made in good faith by the commission in applying what they understood to be the standard.
Mr. Giebner?
Just jumping in on, following on what I said earlier, Mr. St. Croix is right, and in that the city, when we receive a sunshine complaint, the department is not required to produce page after page of entirely redacted information. But if there is substantive information in the document and can be revealed with released with minor redactions, that's when we would suggest redacting. And so there's a fair amount of judgment in that, and that goes to Commissioner Stucker's point.
But we are not are we prohibited from releasing a document with no substance?
And I think when this document is produced, in my view, it would fall on the end of the redactions that I would categorize as so severe as to be virtually encompassing the entire document. So I think because Ms. Herrick suggested it be produced, because she conducted this investigation for us, because I didn't find the information that was not redacted to be privileged, I think in this instance, production is appropriate. But I certainly do not fault the commission for not producing a document in this form, which the public can evaluate it once they see it, but I think they will find it to be not particularly useful as a publicly disclosed document. Thank you, Mr. St. Croix. Do we have to take a vote? What should we do, Mr. Givner?
I would suggest we take a vote on this motion.
Is there a motion with respect to whether we should find the failure to release these 3 documents in redacted form to be a willful violation of the Sunshine Ordinance?
I move that we find that the failure to release these documents was not a willful failure, a willful violation of the Sunshine Ordinance.
Is there a second?
Second.
All in favor?
Aye.
Opposed? Motion passes. I also want to say, in response to a number of the members of the public, that I understand the frustration with not being able to see what we get to see, what the Controller's Office sees, and what the Commission itself sees. These investigations are fact-intensive. The Commission spends a lot of time on them, and I would really like for you to be able to know and to prove that to you. We are bound by rules of nondisclosure. We are bound by the Charter and state law. And there's good reason for confidentiality, as I think I said at the last meeting. We need to protect whistleblowers. We need to protect people who talk to Commission investigators and Controller's investigators in order to try to make this system work. So I don't think I'm alone in sympathizing with the difficulty in being able to see the documents, but there is good reason, and the law requires that we not allow it to be disclosed, in our view. The next item on the agenda is discussion and possible action on the Ethics Commission budget. Mr. St. Croix, would you like to introduce this matter?
Okay, so the numbers breakdown is before you in the memo. We've been asked in the past several budget years, due to difficulties with city budget, to make cuts that were so substantial as to that would prove damaging to the Commission's mission. This year, although budget news is good, it's not fantastic. And the mayor's office is requesting what seem to be very minor cuts for the next 2 fiscal years, approximately $34,000 in each of those years from us. Our prior custom has been to respectfully request that our budget not be cut, but not ask for increases, so that we maintain our independence as an independent agency in making these decisions, but yield to the reality of the budget year. I have not made that recommendation this year. It's really going to be a policy call for the commissioners. If I have to make a $34,000 cut, I believe it would cause us some pain, but I believe it's doable. On the other hand, there's things we need to do that just aren't getting done, and so looking in the long term, we just don't have enough staff for everything that's going on. So a possible approach would be to accept the cut in the spirit of cooperation, but direct me to work with the mayor's office and the board to try to get it restored through the budget process, which would again be a sort of solution of sorts. It would accede to the mayor's budget demands, but it would also leave open the possibility that we could work something out. I would like to introduce Our new budget officer, Mr. Cunningham, works for the mayor budget office. Jason, if you want to come up and introduce yourself. We have this sort of revolving chair in who our budget analyst is. Sometimes I think it goes to the person who's the newest in the shop or who loses the twin cost. I'm not sure, but I'm suggesting that as a likely possibility. If you have any questions for the budget analyst, now would be the time to ask.
And I would state that I've only been in this job for about a month, so I may or may not be able to help you out with your questions, but I'll definitely be willing to listen to anything you guys have to say.
We appreciate your coming nonetheless.
Oh, not a problem.
I don't have any questions. Does anybody on the commission have questions for the budget analyst?
Not really, no.
And was it Mr. Cunningham?
No, I look forward to working with Mr. St. Croix, and we'll see where we go. Thanks.
Thank you.
Thank you.
I have a question. I have a question of Mr. St. Croix. So when you say that there are things that you'd like to get done that you aren't able to get done currently, what are some of those issues?
Well, we have two extremely competent investigators, but I think we could do more if we had another one. We have the slot, in other words, the position, we don't have the money. Right now we audit all public finance candidates and a random sampling of all other candidates. Eventually, I think we should be able to audit every single candidate. Auditing is one of the most effective tools we have, anti-corruption tools. And we want to continue to expand, the services that we provide to the public in overseeing the regulated community. The audits that we do right now are taking longer. We're trying to do more, but the mayoral audits, for example, we only had one real audit to do in the last mayoral election. And in this one, we had a lot more. And mayoral audits take longer than supervisorial audits, for example. We've gotten much better about getting out notices of fines and other responses to infractions, but I would like to do more than that. We want to move toward monthly reporting of consultants like we do with lobbyists. So that's going to take a little more effort, things like that.
Any other recommendations or comments for the executive director with respect to the budget? I think given what we want to do, I think given the public concern about our investigatory budget, given that the public wants us to do more investigation based on certainly what we hear in front of us, I would be fine with you doing what you've typically done and not propose a budget cut.
Okay.
I think certainly the public relies on us to some extent for our investigatory work, and I think we want to continue that and certainly not diminish that as a result of budget cuts, in my opinion. Any other comments? Is there public comment on this matter?
David Pilpel, a number of items, starting with the memo. I don't know why Commissioner Rennie fell off the letterhead here. I apologize, and I hope he is still with us, and perhaps it's just an oversight. Plus, the date on here should be 2013. This is actually not a lot of detail. It's like no detail, and this is actually a required annual hearing on the budget pursuant to the charter. I appreciate Commissioner Haon's question and the director's answer. I think in whatever transmittal comes from the commission and the staff to the mayor and the controller should include some of that language about things that aren't getting done, could be done better. I think that very much supports the budget request. And I think that in general terms, the commission should not accede to the cut request, probably should not make a request for additional funds at this time, but should note that there is additional work that could be done with other resources. And hey, I will continue to say if there's a need for a cut, I think we should reevaluate the cost of being on SFG TV and reserve those funds for only those public hearings like the Mercury matter last year that were of great public concern. I think tonight's meeting is a good example of why we don't really need to be on TV. Sorry. I would also note that some of the programs that the Commission runs have fees that don't fully cover their cost. And I've said many times before, whether it's the consultant program, the lobbyist program, or other things, that we should either set fees to cover the full costs, or at least know what the full costs are and acknowledge that we are supporting those programs with general fund dollars to some degree. And where there are differences, try to level them off and say, rather than covering 18% and 32%, we're going to set as policy that we're going to cover about 25% of our program costs through program revenues. I'd also note that there's a new state law that now requires campaign filers to pay a $50 annual registration fee to the Secretary of State. I don't know if we would be able to do that here. If we were, that would be interesting, and we could cover some of our campaign filing related costs through that program. I'm not suggesting that the audit or public financing program costs should be covered, but there's certainly costs related to filing of statements that are now being borne by the general fund. So I think we should look more carefully at what are general fund costs and what could be program costs. I'll leave it at that, unless there are questions. Thank you.
There's no action that needs to be taken, does there? Is there?
Well, normally you would have a vote.
A vote.
Affirm the action that the Commission has directed me to take.
Is there a motion to affirm the executive director submitting a budget that does not include the requested 1.5% cut in the department's funding?
Second.
All in favor?
Aye.
Opposed? Hearing none, the motion passes. The next item on the agenda is discussion and possible action regarding a complaint received or initiated by the Ethics Commission, possible closed session. Public comment on all matters pertaining to agenda item 6, including whether to meet in closed session.
Yes, I'd just like to request that you be as specific as possible regarding the arrangements for reconvening the meeting and the minimum amount of time it might take.
The minimum amount of time it might take, difficult to determine. I would. Do we give these estimates?
Yeah, I just don't really have one. Probably half an hour.
Probably half an hour would be my guess, but it's hard. It's very difficult to determine in advance. Is there a motion to move into closed session under Charter Section C3.699-13?
So moved.
Second.
All in favor?
Aye.
Aye.
Opposed? Hearing none. We will move into closed session.
With all due respect, you didn't answer the other part of my question. Are we going to leave? Are you going to notify people we're standing in the hallway? Should we wait here while you retire to another room?
Oh, no. If you could leave, that would be great. Sorry.
And you'll notify people waiting in the hallway
Yes.
when
Yes.
you
Yes.
Yes, sir.
SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television. SF TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television.
You don't have to. Okay.
Okay, and I'm sorry.
Oh, wait, I'm sorry.
Yeah, I do have to vote.
I beg your pardon.
That's all right.
Certification.
Yeah.
Okay, we're back in open session. Is there a motion to keep the discussions and deliberations relating to the matter that was discussed in confidential session, keep that confidential? That's perhaps not the most eloquent motion I've ever made.
So moved.
Second.
Second.
Public comment? Hearing none. All in favor?
Aye.
Opposed? There are none. Mr. St. Croix, can you make the announcement?
Okay. Finding of probable cause for Ethics Commission Complaint 13-111013 at its regular meeting of January 28, 2013, in the matter of Ethics Complaint number 13-111013, the Ethics Commission made a determination that there is probable cause to believe the following violations of the San Francisco Campaign and Governmental Conduct Code occurred, and that the respondents, Cesar Escalons and Bessie Natarino, committed them. One violation of San Francisco Campaign and Governmental Conduct Code, Section 1.116, subsection A2, for reporting and receiving a loan to his candidate committee in excess of $120,000. 2, one violation of San Francisco Campaign and Governmental Conduct Code, Section 1.116, subsection C, so for repaying a loan amount in excess of $120,000. 3, one violation of California Government Code, Section 81004, Subdivision A, as incorporated into local law by San Francisco Campaign and Governmental Conduct Code, Section 1.106, for not accurately reporting either the correct amount of the loan that the committee incurred or the date that the loan was actually deposited into the committee's bank account. 4, one violation of San Francisco Campaign and Governmental Conduct Code, Section 1.109, subsection A, for not providing documents that were required to keep within 10 business days after a request by Ethics Commission staff. 5, 15 violations of California Government Code, Section 84104, as incorporated into local law by San Francisco Campaign and Governmental Conduct Code, Section 1.106, for failing to maintain detailed records that document the dates on which his committee made 15 expenditures, the amounts of the expenditures, the names and addresses of the payees, or description of the goods or services. 6, 15 violations of San Francisco Campaign and Governmental Conduct Code, Section 1.108, Subdivision A1, for failing to make 15 campaign expenditures from the candidate committee's bank account. Each commissioner who participated in a decision to find probable cause must certify on the record that he or she personally heard or read the testimony, reviewed the evidence, or otherwise reviewed the entire record of the proceedings. Each commission must so certify.
Consecutive, you want individual?
One at a time.
Start with Commissioner Rennie.
I so certify.
Yeah, I'll so certify.
I so certify.
I so certify.
I so certify.
I so certify.
The respondents are presumed to be innocent unless and until such time that the allegations are proved in a subsequent hearing of the merits. The executive director shall issue an accusation in accordance with the San Francisco Ethics Commission regulations for investigations and enforcement proceedings. No.
The next item on the agenda is discussion and possible action on the minutes of the Commission's regular meeting of November 26, 2012. Public comment?
David Pilpel on page 3 of the draft minutes, towards the bottom under public comment. Is someone following with me? Sorry. Bottom of page 3 under public comment. Mr. Nee stated that he need clarification. I believe needed would be better. On page 4, public comment, towards the top, my comment stated that the term qualification should be included perhaps in the definition, not into. On the bottom of page 4, item 5, the closed session evaluation of Director St. Croix, I believe that should also reference the Brown Act and Sunshine Ordinance provisions that permit such closed session. And there was one other, one moment. Well, there was one other thing, and darned if I can find it right now. I will try to find it and communicate it to staff, but just minor typographical things. I did try to read the minutes. Thank you.
Is there a motion to adopt the minutes as amended by Mr. Pilpel?
So moved.
Second.
All in favor?
Aye.
Opposed? Hearing none. Next item on the agenda is the Executive Director's Report.
I just want to throw one thing on top of the report. During public comment earlier, a number of people mentioned, the Jewel Gomez case. I did call the mayor's office on Friday to see if a response to us was forthcoming, and they did not have an answer, but said they would get back to me, but did not do so by the time I left the office today. So I did think to follow up on that. I'll let you, if the first question is a response coming? The answer is no. Then, that's that. If it's yes, I'll try to get an idea of when.
Thank you.
Thank you. Any questions from the commissioners on the Executive Director's Report? Public comment?
Bill Pell again, and I did find the other thing on the minutes on page 4 in the middle, the public comment, where I was talking about an insufficient number of commas in the proposed language. I would insert a comma there, which would make the comment more readable. Okay, on to the Executive Director's Report. Trying to liven this up in case anyone is watching this, maybe.
We're watching, Mr. Bill.
Oh, you're watching, yes, that's the most important thing.
Only you got a dime for each of those.
Yeah, okay. In connection with the November 2012 election, I would anticipate that we're going to get some sort of report from staff about the effectiveness of the public financing program. I assume, although I didn't see a survey, that there was a survey after the November election, maybe. So I'm looking forward to hearing more about that. There was reference somewhere in here about, or maybe it was discussed earlier, about the number of audits. There's no discussion in the director's report about the status of audits, where we are, since we're like halfway through the year. Are we halfway through the audits that were scheduled, kind of the, audit status? I continue to note that although I guess we got past the instant issue with Chris Jackson, that we still have an outstanding balance that Mr. Jackson owes the city. I continue to believe that we should publish a list of all the bad actors that have outstanding fees, fines, forms out. And I wanted to note on page 4 the technology upgrades. I like to thank Stephen Massey, the IT director, as much as possible, because he's kind of one of the unheralded staff members who really does a lot in terms of servers and technology and the whole dashboard program. The updates to the electronic filing program really have been helpful, as I understand, and kudos to Stephen for that work. Thank you.
Thank you. And I certainly echo the great work that Mr. Massey and the staff have done on our electronic filing. I do think it has added a lot of value, and I know the regulated community and the public, I've heard, have appreciated those efforts as well. Anything else relating to the Executive Director's Report from the Commissioners? The next item on the agenda is items for future meetings. Anybody like to add anything?
I just want to express appreciation for the interested persons meeting announcement, and I'm glad that we'll be talking about that report at a future meeting. Some of the issues that are raised in the course of these conversations kind of come naturally into the consideration of that. I'm thinking of something like our whistleblower experience, and it'll be I think it'll be useful for all of us to see I think the contemporary word is benchmark, but to have an opportunity to reflect on that, not in the context of any particular case, but in a general way.
I agree. I agree. We need to look at all of our investigations and all of our work and see where we can improve. And I think seeing what's been done in LA and a comparison is going to be a useful discussion. And I hope that we will have significant public participation. Anything else?
Any public comment?
Public comments on agenda item number 9.
David Pilpel. I would remind the Commission, several years ago, we had attached to the Executive Director's report sort of a 6-month forward calendar of intended topics and hearings that sort of withered away after a while. I think that would be helpful to list those things that we know or intend to have happen in the next few months, and those things that haven't yet been scheduled but are intended to happen. There are some things that we know are on an annual schedule, other things as needed. I would really encourage you to develop that and maintain it on a monthly basis, either in connection with this item or the Executive Director's report. I think it would be helpful for you, for the staff, and for the public. Thanks.
The next item on the agenda is public comment on matters appearing or not appearing before the Commission.
Yes, I beg your indulgence in letting me speak again on public comment. I promise never to come again, so we're both ahead in the long run. The library commissioners are appointed by the mayor. One of the library commissioners, Michael Breyer, resigned on June 11. I visited the Ethics Commission's office in the first week in July to ask for the report from the mayor on vacancies. The staff of the Ethics Commission told me that no such report was required. I pointed out that not only is it required under San Francisco Campaign and Government Conduct Code, Section 3.1-105, but the failure to provide such notice is defined as official misconduct. She said, the person who was helping me said she'd never heard of this before. I provided her a copy of the law, which I'd be glad to provide to you if you want. And she said that Mr. St. Croix would call me. I came back a week later to find out why no one had called me, and she said that the mayor would be complying starting next month, even though the notice period is 15 days under the law. I asked a series of questions. Has there been no complaint so far? Do you have any documents relative to this? To each question she responded, I'm not clear on that. After I had gotten that same answer 4 or 5 times, it was clear to me that this was just another cover-up, even before the facts had been established. You have to realize that this comes on top of the abuse and dishonesty that we get every place else. I mean, if the mayor's office is just a gang, and the library commission is just a gang, and there's no reason why they should be socially responsible because the ethics commission is just a gang, then we're just going around in circles. You have to realize that this is, in fact, cover-up. Mr. St. Croix sees himself, obviously, as a situation where everybody else in the city is mostly honest, and I'm the only one who's completely corrupt. Well, the trouble is everybody else in City Hall sees himself exactly that same way. You know, let everybody else be honest. You know, Mr. St. Croix sees himself as a sleazy corporate executive running the Ethics Commission. Well, it doesn't stop there. If there's no ethics at the Ethics Commission, there's no ethics. It has to do with all kinds of disclosures about finance that I would like to get. But if he's just going to tell the malefactors before the investigation, what's the use?
Any other public comment? Is there a motion to adjourn the meeting?
So moved.
Second? All in favor?
Aye.
Hearing none, motion is adjourned, or the meeting is adjourned.